Okay, so welcome everybody to our webinar this morning. We're going to give you a bit of a whistleblowing update, and I'm joined by my colleague Michael Halsey. And between us, we'll go through the current law, but also some potential changes and some practical tips. Just before we get going, I'd like to say that obviously this session is recorded, as it says on the slide. We will provide a copy of the slides after the event. If you have got any questions, can you please put them in the Q&A box as we're speaking, and we'll look to take questions at the end and provide any clarification or anything else that we can help with at that point. If you've got any technical issues, the usual IT fix generally works with maybe just logging out and then logging back in again. But if you're really having persistent problems, please put them in the chat, and our events organizer will do their best to try and support you rejoining the call and resolving any technical issues. So let's get started. So this morning we're going to look at a whistleblowing update, and we're going to look at a number of areas in relation to both what the existing framework is, but also where there's various discussion about potential reform, and we'll touch on those. It's an area which develops lots of case law. It's not the most straightforward of areas to apply in the employment situation from time to time. And so we're going to talk you through some of those. And out of that and out of our experience, bring you some practical tips of the areas that you may want to focus on, or how you might seek to manage whistleblowing issues that may arise. It's an area where we, because of timescales and the nature of these webinars, we really are going to give you an overview and an introduction to some of the issues. It's something that's quite complicated in terms of the detail and how a case may develop or how you might respond to something. So we'll do our best to answer questions and go through the top level stuff, but if it's detailed, we may need to come back to you separately. And I'd always recommend that if you're managing whistleblowing issues, then do look at the legislation, think about the areas that are being challenged and how you might want to manage those, including taking advice either internally or externally. So in terms of the overview, therefore, looking first at the existing framework, let's get the slides to catch up with me. There we go. As a setter for that, the reason why whistleblowing complaints can be important and can be time-consuming to deal with is that, rather like our discrimination framework, there's no minimum length of service for someone to be able to bring a claim. It relates to both workers and employees, and we'll touch on that in a bit more detail in a second. There's no statutory cap on compensation, so if someone is able to pursue as an employee an unfair dismissal claim, or potentially a detriment claim as a worker that involves termination of the contract, then in terms of the compensation they can seek, then the usual caps and limits aren't necessarily applied, and it therefore perhaps takes on some of the life of a discrimination complaint in how the risks are assessed in relation to a claim that's maybe proceeding in a tribunal. Clearly, in terms of whistleblowing and the court of public opinion that we all live in terms of how social media works and the difficulties that can present for organisations, whistleblowing complaints can be an area where there's potential for reputational damage and therefore potentially also for commercial damage. So it is an area that organisations generally look to take seriously, both in terms of how they manage complaints, but also how they manage the implications of those where someone feels they've been unfairly treated, or it's because the reason they've complained is then why they think that they may have a detriment or a dismissal claim. Should also note that, as well as largely we're going to talk about how the organisation responds to whistleblowing complaints and the liabilities that sit with an employer, but there is also an element of personal liability in terms of decision makers and being pursued for a detriment claim as an individual in the organisation. Again, that can be something that causes quite a lot of concern. And the usual rules around vicarious liability also apply in relation to an employer's overall responsibility for the actions of its employees. So again, it's an area that can be quite complex, and quite often we see that whistleblowing complaints can be introduced as part of looking to strengthen a claim, bolster a claim, or get an employer to take it seriously, and therefore can be something that's used in the negotiation process. Quite often you might see that you start off a redundancy process or a performance management process. An employee feels or a worker feels that the way in which their matters are being dealt with, that there's a wider background, and they maybe seek to bring a whistleblowing complaint, which can then really complicate things in terms of how you resolve the employment issues and your process. It's also, if you ever get to tribunal stage, important to note this is an area where a claimant can apply for interim relief, and that essentially means that they continue to receive a level of earnings whilst the tribunal proceedings are progressing. So it can be quite an expensive undertaking in terms of the process and how things are dealt with. So that's why we need to take them seriously. And then we've got the framework that I'll just very briefly talk you through in relation to the key areas of a whistleblowing complaint and the legislation. So it was the Public Interest Disclosure Act back in 1998 that essentially inserted provisions into the Employment Rights Act that's related to the right not to suffer a detriment and potentially not to be dismissed for making a disclosure. So it allows an individual to raise concerns in a controlled environment where potentially they hopefully would not be then subject to victimization or detriment as a result of that. In terms of making a disclosure, there are two parts to that. First of all, the disclosure needs to be what's known as a qualifying disclosure, as in it relates to one of the 6 categories of public interest concern. And these are set out in the statute, but very quickly, they relate to things like criminal offences, breaches of a legal obligation, miscarriages of justice, dangers to health and safety of any individual, including the person making the complaint, damage to the environment, or a concern that something is being deliberately concealed in relation to any of those 5 categories that are listed. And so when you're getting a whistleblowing complaint, obviously it's understanding the nature of that complaint and the information you're receiving, and is it a qualifying disclosure in legal sense. Obviously, you'll have policies and procedures in terms of your own organisation as to how you wish to manage issues. So in relation to those types of things, it may well be it's broader in your policies, but if you're getting into the territory of dealing with a claim, that's where you'd want to focus on, is it a qualifying disclosure? If it's a qualifying disclosure, in terms of someone bringing a complaint, it then also needs to be what's known as a protected disclosure in terms of how you then look at whether there's been a detriment or it's the reason for dismissal. And for it to be a protected disclosure, basically that's giving a nod and an examination of the way in which the disclosure was made. So was it made to the employer, or was it made to an authorised or prescribed person within your regulatory framework, or within certain limited confines, was it made to an external third party? Obviously, if someone just blows the whistle on social media or to the media generally, potentially that is then not a protected disclosure because they haven't followed the processes that you've set out and the way in which you'd expect it to be dealt with. And as we've noted already, if someone is deemed to be making a protected disclosure, they then have protection against not being subjected to detrimental treatments, having made that, or potentially being dismissed where the reason is that they've made the disclosure. And obviously one of the tricky areas can be the extent to which at times that cuts across confidentiality obligations or non-disclosure obligations in terms of someone feeling the need to speak out and raise issues. So going into a bit more detail then in terms of the current framework, the question that often comes up is who is protected, and obviously the way in which it's drafted is to basically use the language of a worker as well as an employee. So it's clear that employees are protected in terms of enhancing an employee's rights, but the legislation also gives rights to workers. The same definition in terms of employed personally under a contract to provide services that you'd see maybe when you're managing minimum wage or holiday pay or deduction types issues in terms of the worker rights that are accrued. So it therefore is much wider, and there's been quite a lot of satellite litigation over the years as to who falls within the definition of worker. So therefore people like LLP members and others may well fall within it. We're going to look at some case law, and as you'll see on the slide, there's a reference to one of the cases Michael's going to talk about that's clarified At present, it doesn't apply to job applicants. So if someone is raising concerns but they aren't yet engaged by the organisation, they don't get the protection. It doesn't apply to volunteers. So if you're an organisation that has a number of volunteers and they raise concerns, to have a different process maybe as to how you receive those complaints or concerns. It doesn't apply to non-executive directors at the other end looking at your board, although interestingly, some of the case law has established it applies, for example, to judges. So who is an office holder, and a question as to whether a director is also an office holder, and therefore someone tested that again in case law, whether you get a different outcome. So it's basically a broad group of people who have been engaged by the organisation essentially has protection. And then the level of protection is obviously then around whether it's a qualifying disclosure, as we've I mentioned in the last slide, in terms of the nature of the concern. But for it to be a qualifying disclosure, it needs to disclose information. So if you're, so it needs to basically convey facts. It can be verbal or written, and obviously that's quite often where we might see disputes in terms of where something is said. By video, someone could video something and then forward that and say, these are the concerns I've seen. But it has to be more than just raising a concern or making an allegation. So the sort of, there's an often quoted case where they looked at this in an NHS environment, hospital environment, and the courts at that stage made a distinction. If someone is saying you're not complying with your health and safety requirements, that's really just either an allegation or a concern. It's not really giving any information for the employer to act on. So that wouldn't fall within a qualifying disclosure. But if someone went further and said, because the wards are maybe not being cleaned or haven't been cleaned on a regular basis, yesterday they saw some sharps or other medical equipment lying around that was clearly unsafe and raising a health and safety concern, then that is giving information. That's something tangible as an employer you could then deal with, and potentially that then is a disclosure of information. Obviously, the subject matter of that information is important in terms of falling with one of the categories we've mentioned. And also, it can't be just that somebody is jumping on the bandwagon and raising something. It's a subjective test, but there needs to be a reasonable belief in wrongdoing, and as therefore why the concern is being raised. And there needs to be a reasonable belief that it's in the public interest. Essentially, those categories are the ones that are deemed to be the ones where there might be a public interest. It could be within those, but then it has got to be something that's relevant to the wider public. So there's a bit of satellite navigation litigation around again whether that is something that is always met as part of the test. It is subjective and it is a question of fact, and it's one of the areas that sometimes makes this a difficult area to navigate. Okay, so that's the framework of the legislation and the types of issues that you'd have to get to grips with. Michael will bring that to life in a second by looking at some of the cases and some of the practical tips in relation to it. But the other area that you regularly see some commentary on in relation to the whistleblowing framework, and if you are an owner of a policy or a procedure within the organisation that deals with whistleblowing, then it's worth keeping an eye on this. There's been various suggestions and various discussions, either from government or from charities such as Protect, to basically look for changes and clarification in our whistleblowing law. And the one that's currently ongoing is something that was launched in March 2023, when the Department for Business and Trade said that it was going to basically undertake a review of the current whistleblowing framework. And it had some research questions. It's not an open consultation, but it said that it would go to employers, it would go to interested groups and stakeholders and to charities to understand basically a series of questions as to the existing framework and whether it is working and whether it should inform policy going forward in terms of how whistleblowing protection could be improved. As a summary on the slide of the areas to be reviewed, but the research questions that they're asking themselves and asking others is how has the existing framework facilitated disclosures? So does it work? Do people feel confident to make the disclosures in the first place? And obviously the follow-up to that is, how has it protected workers? Is it sufficient in terms of creating the right environment for those disclosures to be made? Is whistleblowing information available and accessible to workers relation to resources, both within an organisation as to what an employer is required to provide, but also maybe externally, what's available to employers. We have various guidance issued by government and ACAS. They're not statutory codes, so they're not things that will be taken into account by an employment tribunal, but there is guidance out there that's, again, what is best practice in relation to how an employer should manage whistleblowing concerns. And then essentially a bit of a review as to what's the wider benefits and impacts of the whistleblowing framework. And again, therefore, in terms of why we have it and why we might change it, what works well and what doesn't work so well. And then what does best practice look like in terms of what would be expected of an organisation in the current age where a level of transparency is expected and a way of being responsible in terms of how we manage our businesses in relation to that. And that's where, although it's not going to have direct effect, there's an EU directive on whistleblowing that is post-Brexit, so it's not something that directly applies to us, but it sets out a number of requirements about how you might establish a channel for internal reporting of relevant disclosures and how you might manage the process. And again, if you're looking at the way in which best practice works, it may well be that government would have a nod at least to that directive. Again, we're still very much integrated with parts of Europe, how we do business, so there will be expectations are set as to what an international organisation should do in relation to how they manage these issues. So at the moment, the timescale of what the review and the outcome of that review is left open. They did say that they were gathering evidence with a view to concluding their review at the end of 2023. We're now in March 24, almost at the anniversary of when they triggered the review, and we don't yet have any oversight as to when it was. The anniversary is 27th of March, so whether next week we'll hear a bit more, let's see, but it may well be that there are other priorities. It's gone a bit to the long grass in terms of how they're going to grasp the issue going forward. Okay, so that's the framework, and that's potentially where at a high level they may look at reviewing how the whistleblowing framework currently works. Michael's now going to take you through some of the case law in relation to areas where the rules have been applied and how they work in practice.
Okay, good morning everyone. Thanks, Gareth. So I'm going to look through 3 cases before we look at some practical tips. And the first case is Kong versus Gulf International Bank. And it looks at whether an employer can dismiss or discipline an employee for the way that they've behaved when blowing the whistle. Excuse me, I'll just take a drink of water. So looking at the facts first, Ms. Kong was employed by the bank as its head of financial audit. She had concerns that the bank was using some financial compliance templates in an inappropriate way and reported this to the head of legal, Miss Harding. She reported it verbally and in writing. And later, during the litigation, everyone accepted that the reporting of these concerns had amounted to a protected disclosure. Miss Harding, however, was upset by the way that Miss Kong had spoken to her. She felt that Miss Kong had questioned her professional integrity when raising the concerns, both when she spoke to her and in the subsequent email. Miss Harding complained about Miss Kong's behaviour to the head of HR and the CEO at the bank, and indicated that she no longer wished to work with Miss Kong as a result. The head of HR and the CEO then decided to dismiss Miss Kong on the basis that she had demonstrated insensitivity and a lack of emotional intelligence in the way that she conveyed the personal criticism to Miss Harding, resulting in colleagues not wanting to work with her. After the dismissal, Miss Kong brought an ET claim on 2 grounds. The first was ordinary unfair dismissal, and the second was automatic unfair dismissal on the grounds that the reason or principal reason for her dismissal was she'd made the protected disclosures to Miss Harding. The ordinary unfair dismissal claim was successful because the employer hadn't really followed a process when deciding to terminate her employment. However, the whistleblowing claim failed, and the courts found that the reason for this was that the head of HR and the CEO decided to dismiss because of Miss Kong's behaviour towards Miss Harding, as reported to them by Miss Harding, not the fact that she'd blown the whistle. And interestingly, it reached this conclusion even though it found on its own investigation that Miss Kong's behaviour towards Miss Harding hadn't in fact been particularly unreasonable in their view. So the case demonstrates that employees and workers do not have immunity for their behaviour related to the making of a protected disclosure. In other words, it's possible to separate an employee's conduct when making a protected disclosure from the disclosure itself. However, every case will need to be looked at on its own facts, and the Court of Appeal stressed this, how careful employment tribunals must be when considering what actually motivated a decision maker to discipline or dismiss. And that's particularly true where the alleged behaviour or misconduct is not particularly extreme, as in the case with Miss Kong potentially. In many cases, causing upset to the person that you're making the disclosure to may not be enough to be able to separate that from the disclosure itself. So in summary, separating the way an employee makes a disclosure from the disclosure itself is possible, but it's not an easy line to tread. So moving on to the next slide. And this is Ajaz versus Homerton University Hospital NHS Trust. It's quite a narrow in scope, this case, but it does have some important wider learning points, particularly where employment continues after an employment claim has been settled. So looking at the facts again first, in 2017, Dr. Ajaz brought a whistleblowing complaint against the trust, her employer, and in its defence, the trust disputed whether or not Dr. Ajaz had made a protected disclosure. The parties then later agreed to settle the case using a COT3 via ACAS, and I'm sure you all know COT3 is the name given to the ACAS forms to use to settle claims, and the parties usually populate those forms with their own settlement terms, and the first draft of those terms is usually put forward by the employer. There's no need to go through Dr. Ajaz's COT3 in detail, but the main points to note for the purposes of this discussion are that the COT3 was entered into without any admission of liability from the trust, and it purported to settle all issues and complaints in relation to the 2017 claim. So fast forward to 2019, and Dr. Ajaz lodged a new whistleblowing claim alleging more detrimental treatment as a result of the same alleged protected disclosures mentioned in the 2017 claim. The new alleged detriments post-dated the COT3, so nobody knew about them when that COT3 was entered into. When it got to the tribunal decided to strike out Dr. Ajaz's new claims, and this was upheld by the appeal tribunal. The problem for Dr. Ajaz was that the COT3 in 2017 settled all issues relating to the 2017 claim, and that included whether or not she had made a protected disclosure, because that had been disputed by the trust at the time. In 2019, she couldn't reopen that issue again in her new claim, as that would be an abusive process. So to an outside observer, I think that case looks quite harsh because it prevented Dr. Ajaz from seeking redress in respect of new alleged detriments, and we don't know whether those detriments were real or not. And those detriments weren't known about in 2017. And in theory, it leaves her open to detrimental treatment in the future, which might relate to the alleged protected disclosure in 2017. But I think the wider lesson for all the parties is the need to think carefully about the terms of any settlement agreement that you enter into, particularly when their employment is continuing. In this case, Dr. Ajaz should have excluded the issue of whether she'd made a protected disclosure from the scope of the COT3 agreement in 2017. And at the time, it would have been for the employer to decide whether it wanted to enter into a settlement on that terms or not. So moving on to the next slide, which is the final of the three cases we're looking at today. It's Sullivan versus the Isle of Wight Council. And this one's about status, something that Gareth looked at earlier, and the ability to bring whistleblowing claims in the tribunal. So looking at the facts again, Ms. Sullivan applied for 2 jobs at the council. On each occasion, the council emailed her to thank her for taking part, turning her application down, but telling her she'd done quite well at the interview. And on both occasions, Ms. Sullivan replied to those emails thanking the interviewers for their time. However, about a month later, after the second interview, Ms. Sullivan lodged a complaint with the police, alleging that she'd been subjected to a verbal assault during the interview. At the same time, she also lodged complaints with the council, saying that the interview panel had repeatedly called her mentally insane during the interviews. She also made allegations of financial irregularities against some members of the interview panel. The council investigated the complaints under its complaints procedures and found there was no case to answer. It then decided not to allow a right of appeal on the basis the investigation had been extensive and it wanted to protect the well-being of its staff. Ms. Sullivan then brought a whistleblowing claim, alleging that the financial irregularity allegation amounted to a protected disclosure and the refusal of an appeal was a detriment. Her claims, however, didn't get off the ground because the tribunal and the appeal tribunal determined that external job applicants are not workers or employees within the meaning of the whistleblowing legislation. Ms. Sullivan tried to run an argument that she should have been given access to whistleblowing protection on a human rights basis, but that argument failed. So looking at the case more widely, it's worth remembering that there have been cases where Ms. Sullivan's human rights argument has succeeded, for example, in respect of judicial office holders, and that was referred to briefly by Gareth earlier. It's also true that there is an extended definition of worker for the purposes of whistleblowing claims in the Employment Rights Act, which refers to a range of occupations in the armed forces, security services and Parliament, as well as various NHS contractor posts and applicants for some jobs within the NHS. However, the case makes it clear that the definition does have limits, and it's now pretty clear, I think, that external job applicants outside of some specific examples in the NHS will not be covered. So moving on to slide 10, moving on to the practical tips. So the first thing is laying good foundations. And there are a number of points on the slide. And I think the key is embedding the right culture within an organization, maintaining effective policies, and training managers and staff. In respect of culture, I think it's often said, and it's true, that ownership of whistleblowing policies should be at a very senior level and should be seen to be being advocated by the leaders of an organization in order for it to have proper force. And it's also really important to think about the training of managers and staff. Just having the policy is not really enough. It needs to be properly communicated and understood. Moving on to the next slide. So we have a poll now, and it'd be really helpful and interesting to have your views on these questions. We as a business have been produced some e-learning tools around whistleblowing, and we're looking to develop those further. And it'd be really useful and helpful for us, for our research, if you could respond to those questions and let us know what you think. I've just got to move something over so I can see them. So the first one is, do you currently provide any training on whistleblowing? And the second one is, would you be interested in a bite-sized e-learning course on whistleblowing for your staff? If you could vote now, I'll just give it a few seconds while those votes come in.
Thanks, Michael. We've
Okay.
closed the poll. I think everybody who wanted to vote had a chance to. So thanks very much for the participation.
Okay. Gareth, can we see those results now? Do we move on?
No, we're just going to move on to the
Okay, that's
slides. We
fine.
will obviously use it as part of our research as to what
Yeah.
will be useful.
Thank you so much, everyone, for doing that for us. So moving on to the next slide, which is responding to concerns. Obviously, the first thing is that we need to have an effective investigation by well-trained and objective investigating officers. Clear terms of reference are really important at the start of any investigation, and clear timeframes. All of that demonstrates the concerns that to the complainant that concerns are being taken seriously, and that that message is really important, I think. The third point there is managing confidentiality, and I would normally expect that to be sort of mentioned in your whistleblowing policies. Complainants quite often ask if they can remain confidential, and most policies and organisations would be sympathetic to that. However, I think you need to be careful about making absolute promises on confidentiality early, because it may not be possible to keep that promise in the long run, depending on how the case develops. It's important too not to confuse confidentiality with anonymity, I think. Most policies will discourage anonymous reporting, as it makes allegations difficult to investigate effectively. The next point is effective feeding back to the complainant. And again, it's that point that not only does a proper investigation need to be done, it needs to be seen to be done for people to have faith in the process. And the extent to which you feed back, I think, probably needs to be looked at on a case-by-case basis, depending on what the investigation has brought up and what confidentiality issues have arisen, and not just for the complainant, but for the others involved. After the investigation, I think it's important to be able to demonstrate that the organisation has reflected on any lessons learned, and that these have been communicated to the appropriate individuals to be actioned. And finally, following feedback to the complainant, if they're not satisfied, most policies will allow for an appeal route. And the point on the slide here is that should really go to a pretty senior level in the organisation, if not up to board level. Moving on to the final slide, which goes back to the case of Kong and the separation of the way someone has behaved from the fact that they may have blown the whistle. And this talks about what you might need to do to address those sort of issues. The first thing to stress, I think, is that these sort of cases are really potentially complicated. As I said earlier, talking about the Kong decision, it is possible to separate the way someone's behaved from the fact that they've blown the whistle, but it's not an easy line to tread. So the first point here is separating the issues, and it's important to do this right from the start, to be clear why you're taking action against the whistleblower, dismissal or disciplinary action, and to have a clear line between those reasons and the fact that they may have blown the whistle. I think if you're going to take advice in relation to these matters, I would take advice early, at this early stage, to ensure that you get off on the right foot and go in the right direction, because it might be difficult to repair later on if dismissal or disciplinary invitation letters or allegations have mixed up the fact of the whistleblow with the alleged behaviour. Follow a fair process, always important, of course, but particularly so here. Keep contemporaneous records to evidence decision making, and tribunals are always going to be more influenced by contemporaneous documents which record people's motivations for making decisions. And as I said earlier, what they'll be focusing on in cases like this is what motivated the decision makers. And clearly explain the reason for dismissal in communication with a member of staff. And again, that's going to be a key document when you explain what if there's detrimental treatment to the individual, you explain clearly why that's been taken and what has motivated the decision makers to make that decision. So that's the end of the slides. I think we're now going to move on to any questions that have come in whilst we've been speaking. Gareth, I don't know if you've had a chance to look at those while I've just been talking there.
Yes, yeah, I can maybe just take them in order, and then we can work out whether we've answered them as we've carried on speaking or whether we should comment some more. So the first one was, what information does a whistleblower have to provide to show they've received detrimental treatment? And I can start with that one. I suppose it's there's always a causation issue. There may well be a protective disclosure, but then what's happened next? So you might need to look at the reasons why. But then in terms of detrimental treatment, it's not further defined. It's a question of fact. So if someone continues in employment, do they feel they've been overlooked for a pay rise, or do they feel that they have been promoted as quickly as they might otherwise have expected, or their manager is just making their life really hard for them? You may sometimes see these types of concerns being raised where there's then a performance management process, and there's concerns that someone is being treated differently. They argue their performance is not below standard, and really what's happening is that they've raised concerns, and this is now the organisation taking issue with them through another formal process. So if someone is alleging detriment, you just have to take it on they need to articulate what it is, and then you need to work through a process as to whether you are fairly applying your policies, your processes, your decision making, make an inquiry as to both in terms of you've got to the point of has someone blown the whistle in an appropriate way, and if they have, are they being treated differently, and is the reason for that because they've raised concerns, or is it something that relates to the way in which they're behaving or their conduct? So as Michael has talked about, both in terms of case law and practical tips, being very clear about what the issues are and what the concerns are, what the organisation is doing, and decisions made, and whether you can try and separate some of that out. Do you got anything else to add on that one, Michael, or shall I move on?
No, I don't think so. No.
Cool. Okay, so the next question then was, would a governor in an independent school be a non-executive director? And I think they probably would fall within that category, but in terms of the whistleblowing legislation, because they may well be an office holder, but they may well not be a worker, because there's no, generally being a governor is a voluntary position. You essentially may or may not have agreed to undertake various activities. Generally, you're not remunerated for it. So I don't know if you necessarily otherwise fit the definition of worker, but it's at the boundaries and edges of it. I'm not aware of any case law that formally challenges it. Michael, are you?
No, I'm not aware of anything.
No. And I think the other thing to say is, obviously in the governor environment, generally in independent schools, the majority of them are charities, and therefore there is a charity framework in terms of serious incident reporting and the way in which someone may raise concerns. So you'd expect a governor to raise concerns with the board and with the chair, depending on the issues. If they're not satisfied, their recourse would be to go to the charity commission in relation to their concerns. But whether they then have the protection in relation to detriment, I think they probably fall outside of the scope. The next question is then whether we have seen an increase in people essentially weaponizing whistleblowing to deflect from other formal processes that may be involved in. We've touched on this in a couple of areas. And if they make an allegation in a formal process, would this be considered a protective disclosure? I'm happy to kick off. I think the answer is broadly yes. As I alluded to, I've certainly seen redundancy processes where someone starts a redundancy exercise and they cry foul and say this is because of concerns they've raised, the way in which things have been dealt with, performance management or other sort of management processes can quite often trigger someone with a sense of grievance as to how they're being treated, and may well invoke the whistleblowing concerns and the process in terms of pointing to disclosures that they've made. Obviously, then there would have to be a factual inquiry into that. So this is where being very clear about what's being said and the process is important in terms of the practical tips of how you might deal with these. Can you separate out the issues? What is a fair process to follow? It can be really frustrating because rather like in a similar walk where maybe raises a discrimination concern as part of a redundancy process or other management process, and say that's the real reason for why they're being managed in the way they are. That's again the guidance is and the best practice would be to just to be on inquiry as to whether process is tainted some way and try and resolve that issue before continuing with your process. And obviously that certainly in a whistleblowing context can be quite very fact heavy, can require some form of investigation, can really slow a process down. So it is a real challenge for employers to be able to sort of get to the nub of an issue and work out whether they should take the disclosures and the concerns on detriment as part of the process, or whether you can potentially try and box them off and run things in parallel. But that can be really quite difficult in relation to a sustainable process. Michael, have you come across similar things?
Yeah, I mean, I think where it quite often crops up is if senior individuals in an organisation are let go within the 2-year period of continuous employment and don't have access to ordinary unfair dismissal. And even if they do have access to that, it may not, depending on their remuneration package, be a particularly rewarding type of claim for them to bring. And senior individuals will often have had discussions at high level about strategic issues, about financial issues and other things. And I think it's fairly well established that people will look around and try and account for the reason for them being let go by potentially attaching that to those discussions, alleging that their position amounted to a whistleblow in relation to some sort of financial practice or something else like that. So it can be a sort of place for senior individuals to go when maximising the sort of impact of any sort of post-dismissal allegations they have, and getting around or trying to get around the problem of the two-year period for ordinary unfair dismissal as well.
Yeah, no, makes a lot of sense. Thanks, Michael. Thank you. Then the next question on a similar theme really is, can an employee bringing a grievance about bullying or other adverse treatment that they have suffered personally claim to be a whistleblower? My starting point would be, is it in the categories that are protected in the public interest? And it may well be that they are not. So bullying obviously doesn't have a legal definition. It's a wide definition about basically unwanted conduct and harassment in relation to how someone's being treated, are they experiencing some form of intimidating or unpleasant environment in which they would otherwise work. That in itself may not be a breach of a legal obligation or a danger to someone's health and safety, but obviously depending upon what they're complaining about, they may be able to then invoke one of the categories and formally say that they've made a disclosure about their treatment. And yes, it can be in the public interest, again, if it's somebody who manages lots of people or it relates to wider issues of what the organisation is being challenged about, as to whether therefore it falls in the public interest and people have a right to know and understand about what the activity is. So I'd start from, if it's personally related, it probably is best dealt with under the grievance process. But if someone is really pushing one of the 5 categories or a wider course of conduct, then you should be alive to that issue and at least ask the question.
Yeah. There are some cases, aren't there, where people's personal treatment at work has had public interest elements to it because, the diminution in their bonus affected a class of employee, for example, and some of the numbers don't have to be that high, do they, for the whistleblowing protection to be engaged?
Yeah, and therefore, yeah, absolutely. I think essentially the employer is put on inquiry at a fairly early stage. But ultimately, the burden of proof in a detriment claim is for the individual, and largely for an unfair dismissal claim, obviously you'd expect the burden of proof as to the reasons for the dismissal to be on the employer. Certainly, if someone has 2 years service and they're bringing an enhanced, if you like, ordinary unfair dismissal claim that they're going to allege is a whistleblowing complaint. If someone's alleging detriment because they don't have 2 years service, including termination of their contract, then I think the burden of proof still rests with them. and it can be just helpful to think about, therefore, what proof do they have, what issues have they raised, and how you might manage or respond to those. So I think thinking about the dispute resolution framework as well is helpful when we're looking at these issues. The next question, again, looking at complaints and grievances and appeals, it says where you have a complaint or a grievance or appeal which combines protected disclosures with other issues, would you advise separating them out and running two parallel processes or combining them?
I mean,
Michael.
I think obviously it's a case-by-case thing, and it's going to be quite nuanced in each individual case, and these sort of things do get very complicated. I think that one of the underlying problems you don't want to get into is where you have two independent investigations into roughly the same factual allegations, and the risk of those investigators coming up with different outcomes or anything like that. Really, you want one investigation of fact, if at all possible, and then take a view about how you deal with the issues coming out of that investigation of fact, and whether you need to have, you have an independent whistleblowing person to look at it, or whether it can be rolled into another process. Really depends on the facts, I think.
Yeah, and obviously depending on how you drafted your whistleblowing policy, there'd be quite often a cross-referencing into the grievance process and vice versa. So the sort of stages of investigation and then hearing things, albeit you may be then looking for in terms of the terms of reference you set for the dealing with the issues, you may want to think about how you then separate out the outcomes in terms of is the grievance upheld and what's remedial action, but also having then an awareness of the whistleblowing issues and how that might be a recommendation to deal with that under the policy. So I would generally, otherwise you can tie yourself procedurally and not to resolve the issues, look at whether, and this is very specific reasons not to run the processes together so that you can, and hopefully your policies are complementary, but that'd be the starting point. What do they actually say? We're back to whether an individual in the next question who raises a complaint can that be something that amounts to whistleblowing? And the example given is someone complaining that there's been a breach of contract, they've not been paid a bonus that they believe is due to them, and they assert that complaining to the employer makes them a whistleblower, although obviously it's a very sensitive personality to them. When the legislation was first introduced, there was a line of case law around people raising complaints personally and saying that they were blowing the whistle, and therefore the legislation was involved. The requirement for it to be in the public interest was therefore introduced. Later, I think in 2013, it was that came into force to try and tackle that. And it has done to some extent, as there's always there's a higher threshold, essentially. Is it in the public interest? But obviously, depending on, this is where you'd have to do a factual inquiry and to understand more, depending upon what the non-payment of bonus is and why, that could be in the public interest. If you're a large organisation, you have a large bonus scheme, and the reason you're not paying it is because of maybe wider organisational issues, you could see how someone could then start to make cases as in the public interest as to how there's governance in an organisation that is in the public domain generally, and therefore it's in public interest. So the public interest doesn't exclude someone saying that their personal issue is something of public interest going more widely, but it perhaps is slightly more difficult than it was when the legislation first came into place. Michael, there's one then for you, because you were dealing with processes and appeals. It says, you mentioned there should be an appeal for whistleblowing findings. Is this a legal requirement or is it best practice?
I don't think it's a legal requirement, as in there's not a piece of law which says you have to do it. But I think it would be probably best practice to have that provision within your whistleblowing policy in the event that a complainant is dissatisfied with the feedback they've received, for example. And obviously it is different to disciplinary and grievance matters, which have ACAS codes and other points around fairness and everything, because whistleblowing will often be comments on particular practices within the organisation that may not impact upon this individual personally or anything like that. So the manner of the feedback will always be different to those sort of disciplinary and grievances, and you'd need to look at it if the complainant is dissatisfied about whether any further action should be taken. But I think that dissatisfaction, which probably should be registered and considered at a higher level.
Yeah, I think it is best practice because again, you're encouraged, as we've talked about, to create an open environment where people can raise concerns and have confidence that they're properly looked at. And obviously, depending upon what the process is in place, depending what the complaint is, has it gone to the right level? Has it had the right level of scrutiny? If someone is unhappy with the outcome of a first round of investigation, and obviously, if it's a process that's leading to a dismissal, someone's going to ultimately say that they blew the whistle and there was an unfair dismissal as a result. And again, depending on what process you're following there, generally when you give a decision to dismiss, but for some right of appeal, obviously that's a very different process. But you can see how, again, tribunal's going to want to look at an employer has looked at every issue with great care before making a final decision. So it may well also be partially fact specific as to where someone is in their process, but generally can be clearly frustrating, and you might want to be clear about the level of appeal, as in, is it a paper review of what's being said, and it's someone at a more senior level looking at it again to see whether the decision was right, or is it a rehearing, which you generally only reserve for dismissal matters and termination, where you're going to make another factual inquiry and look at the issues again in terms of rehearing. So maybe the policies will already have anticipated that in terms of when they do provide for an appeal, whether it's on a paper review or is there new evidence or something that makes someone look at something again. So you could try and narrow the criteria for when an appeal is invoked. There's a next question is then saying there seems to be an overlap between whistleblowing and dismissal per se. I think that's right. It's an extra element of protection for an individual who may have thrown it. It says, in essence, it must be tempting for an aggrieved employee to introduce whistleblowing or to their grievance matter. I think that's right. But back to one of the earlier questions, I think someone used the word weaponizing in their question. But yes, there is. If you're looking at challenges, as Michael said, if you don't have 2 years service and unfair dismissal, or you're looking to raise the stakes with regard to the value of a claim, then yes, I can see that employees and their advisors would look at whether the facts support a concern that there has been a protected disclosure and there is adverse treatment and or dismissal because of that. We then got one final question which relates to charities, and it says, are charities more likely to have whistleblowing falls in the public interest than another employer? Interesting.
Arguably, yes, I suppose.
I suppose depending on what the charitable objects are and what the organisation's trying to achieve, then potentially, yes, you might say that someone's at. I suppose I would temper that with that those engaged in working with a charity feel very passionately about the charity, and obviously at times there are, and the causes behind it, difficult decisions made within a charity as to how they prioritise things or how they go about things. I'm not sure whether all of that would be in the public interest in terms of how they organise themselves and what their priorities are. But if the concern is undermining the charitable focus of the organisation, then that potentially would be in the public interest. So having said that, there are so many other walks of life in terms of where something that an organisation does, if it has consumers or customers or clients, it probably is in the public interest if it's a criticism of how people are dealt with or how things are dealt with in relation to then how other users may then access or customers access those services. So I think it's probably an area where absolutely a charity should have a whistleblowing policy and have good governance as to how they manage the issues. But whether they're actually more at risk than others in terms of the successful public interest aspect of the claim, I don't know. It'd be interesting maybe to look at that in a charity forum or specifically. Great. That's all of our questions. So I think that neatly then brings the session to an end. So thank you very much for attending today. As we said at the beginning, we will circulate the slides and the recording will be available as well in due course. I think while we've been talking, there's been a poll for which, again, thank you for those who participated in that, giving some feedback on the session today. It's always very helpful for us, both in terms of how we present these webinars on a monthly basis, but also the content of them, to have your feedback and to just make sure that we're delivering something that you find useful and engaging. thanks very much for tuning in, and hope everybody continues to have a good morning. Thanks very much.
Thank you.